Okay, let's dive into one of the most ambitious and, well, frankly challenging global undertakings, setting up a system to protect human rights right across state borders.
Hmm.
I mean, think about it. How does an organization that's fundamentally built on the idea that states are sovereign, within their own territory, how does it grapple with holding those exact same states accountable for how they treat their own people?
It's that classic paradox, isn't it? You've got a system that needs states to cooperate, but it also needs ways to, well, scrutinize them and hold them to account. That balancing act, it really defines the UN's human rights work.
Exactly. And that's precisely what this deep dive is all about today. We're going to take a really comprehensive look at the United Nations system for protecting and, importantly, enforcing human rights.
And it is complex. It's multi-layered, definitely.
Yeah.
But it's absolutely essential if you want to understand the international landscape today. This isn't just theory. It really impacts millions of lives.
Yeah, absolutely. Our deep dive today, it's grounded in, well, quite a stack of materials exploring this whole intricate framework. We've got key foundational documents, some really insightful analysis.
And we should definitely give credit here to the University of London for making these documents available for educational purposes.
Absolutely. We really appreciate that. And this deep dive is brought to you by Sinorbit Academy, Sri Lanka. Our mission really is to help you navigate this material, pull out the most important bits, and hopefully make these, let's face it, sometimes dense topics a bit clearer and more engaging.
Yeah, we certainly hope it's helpful for your studies, for your preparations. And look, to all of you getting ready for exams, really, best of luck. We'll try our best to fly the key concepts, those connections that are just essential for getting a handle on this system.
Okay, so let's start unpacking this thing. To really, really understand the UN's human rights system, we've got to go right back to the beginning to 1945, when the UN was born.
Right. This is immediately after World War II, a conflict that had just shown the world the horrifying results of, unchecked state power, total disregard for human life, human dignity. The UN Charter, that's the foundational treaty. It's legally binding. It literally created the organization. It's the master blueprint, if you like.
And yeah, the top priority, understandably, was preventing future wars to save succeeding generations from the scourge of war, as the preamble says so powerfully. But the vision, it went way beyond just, peace between states.
Oh, absolutely. The preamble, it also explicitly aimed to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women, and of nations large and small. It aimed to set up conditions for justice, for respect for international law, and crucially, to promote social progress and better standards of life in larger freedom.
So it was rooted in human rights, equality, rule of law right from the start.
Definitely. Human rights were kind of baked into the core purpose from day one.
But then, how does that square with, well, the cornerstone principle of international law and the UN itself, state sovereignty? Article 2 of the Charter seems to put up some pretty big barriers there, doesn't it?
Article 2. Yes, that's where you see the tension really clearly.
Mm-hmm.
Article 2, paragraph 1, establishes the sovereign equality of all members. States are equal, they're independent. That Article 2, paragraph 4, prohibits using force against another state's territory or independence.
Okay.
And then, critically, Article 2, paragraph 7, it says, the UN cannot intervene in matters which are essentially within the domestic jurisdiction of any state.
Right, that domestic jurisdiction clause, that's the real friction point, isn't it? Because if how a state treats its own citizens is purely domestic, how can the UN possibly step in to address human rights abuses happening inside a state?
That is the fundamental challenge. It's what the system grapples with constantly. But importantly, the Charter also provided the hooks, the sort of entry points for human rights action, mainly in Articles 55 and 56.
Okay, tell us about those. How did Articles 55 and 56 become the foundation, despite that Article 27 hurdle?
Well, Article 55 lays out the UN's promotional goals. It says, the UN shall promote things like higher standards of living, solutions to global problems, cultural cooperation, and here's the key bit: universal respect for and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion.
So Article 55 explicitly makes promoting human rights a UN goal.
Yes. And then Article 56 is the commitment from the member states. It says, all members pledge themselves to take joint and separate action in cooperation with the organization for the achievement of the purposes set forth in Article 55.
Okay, so states actually pledged to cooperate with the UN specifically to achieve those Article 55 goals, including promoting human rights.
Exactly. Now, the Charter didn't list specific rights, didn't spell out detailed mechanisms, but Articles 55 and 56, looking back, they gained huge significance. You see, in the San Francisco conference where the charter was drafted, things were rushed. Some delegations wanted a full Bill of Rights included then and there, but there just wasn't time. So these articles were put in partly to make sure the General Assembly could take up that idea later. They provided the legal justification within the charter itself to start building the human rights system.
Interesting. So the charter was like the skeleton, providing the basic structure and the aspiration in 55 and 56, but leaving the how do we actually achieve that universal respect kind of vague. How did the UN start putting flesh on those bones?
For that, you look to the main organs of the UN, listed in Article 7,
Yeah.
the General Assembly, the Security Council, and the Economic and Social Council, ECOSOC.
Right. The General Assembly, the big talking shop, it can discuss pretty much anything under the Charter. Article 10 says that, including human rights. And it can refer really serious abuses to the Security Council if they threaten peace, but that's not the everyday human rights work, is it?
No, that's more the exception. The real engine room, institutionally speaking, for the dedicated human rights work within that initial charter framework was ECOSOC. Chapter X of the Charter, Articles 61 to 72, sets out its functions. Article 62 is important and lets ECOSOC initiate studies, make reports, make recommendations specifically for promoting respect for human rights.
Okay, studies and recommendations. And Article 68, that gives it the specific power to create a dedicated body.
Yes, Article 68 is the crucial link here. It explicitly requires ECOSOC to set up commissions in economic and social fields and for the promotion of human rights. That's the direct legal pathway from the Charter to the very first UN human rights body.
And ECOSOC did just that pretty quickly after the UN started.
It did. February 1946. ECOSOC acted on Article 68 and set up an initial sort of embryonic Commission on Human Rights, and its very first major task, draft an International Bill of Rights. That whole process led directly to the Universal Declaration of Human Rights in 1948, and then later to the two big covenants in 66.
Wow. So ECOSOC, using Article 62 and especially 68 from the Charter, is the mechanism that really kickstarts a whole institutional human rights machinery within the UN. That connection is vital to remember.
It absolutely is. It's the direct line from the Charter's promise to the first actual human rights body.
Okay, so the Charter gave us the blueprint, the initial structure via ECOSOCs. The next huge step was actually articulating what these human rights were. And that brings us squarely to the Universal Declaration of Human Rights, the UDHR.
The UDHR. Adopted by the General Assembly, December 10th, 1948, which is now Human Rights Day, of course. This was the main focus for that early Commission on Human Rights. It's often called the common standard of achievement for all peoples and all nations.
And the material makes it really clear, doesn't it, that even though it wasn't legally binding at the time, it was definitely intended to lay out the fundamental standards, the standards that would later get codified into law. Let's maybe explore some of the articles just to get a feel for the sheer scope and the vision it laid out.
Sounds good. Let's start right at the beginning, the foundational principles. Article 1. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. It really picks up on that dignity concept from the preamble.
Yeah, but as the source points out, terms like dignity, brotherhood, they're quite abstract, aren't they? It's a powerful statement, a powerful ideal, but it immediately flags that challenge. How do you actually implement that in a world full of sovereign states with completely different systems, different priorities? How do you enforce a spirit of brotherhood?
Exactly. It sets that aspirational tone. Then you get Article 2, which brings in non-discrimination. And this principle, it really underpins everything that follows. It says everyone gets all the rights and freedoms without distinction of any kind, and then lists grounds like race, color, sex, language, religion, political opinion, national or social origin, property, birth, or other status.
And importantly, it adds that crucial bit about no distinction based on the political, jurisdictional, or international status of the country someone belongs to.
Yes, that clause was incredibly important then. Think about the post-war world, decolonization just starting. It made sure that people in colonies or territories whose status was maybe disputed, their rights were still protected. It applies non-discrimination really broadly.
Article 3 then gives us that fundamental trio. Everyone has the right to life, liberty, and security of person.
It sounds simple, but the complexity underneath is huge. The source calls it deceptively simple. It's fundamental, obviously, but it doesn't answer the hard questions, like when does life actually begin? What about extreme poverty? Does the state have an obligation regarding quality of life? Or is it just about the state not arbitrarily taking your life? This article alone kicks off that whole debate about the nature of rights. Are they freedoms from interference, or are they entitlements to certain conditions?
And Article 5. No one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. This feels like one of the most absolute prohibitions we have today.
It absolutely is. It's seen as an obligation erga omnes, an obligation owed by every state to the whole international community. Now, the source does mention there are debates about the precise lines between torture, cruel, inhuman, and degrading treatment.
Hmm.
But the core prohibition, that's absolute. It's so fundamental it can't be suspended, not even in emergencies. And it gets elaborated in later treaties like CCAR.
Articles 6 through 12 then seem to cluster together, focusing on the rule of law, due process, building on that right to liberty and security from Article 3.
Yes, these are essential for ensuring basic fairness and justice. You've got Article 6, recognition as a person before the law, your basic legal existence.
Yes.
Article 7, equality before the law, equal protection, applying non-discrimination specifically to the legal system. Article 8, the right to an effective remedy from national courts. This is so important. A right without a way to enforce it is pretty meaningless, right?
Totally.
Article 9, protection against arbitrary arrest, detention, or exile, a core safeguard. Article 10, the right to a fair and public hearing by an independent, impartial tribunal, and that applies to both criminal and civil cases. And at Article 11 really digs into criminal due process, presumption of innocence, no retroactive penalties, public trial, right to a defense.
And the source highlights the detail on criminal safeguards, presumably because liberty is so directly at stake. Punishments can be so severe. It does make you wonder, though, as the source asks, is the relative lack of detail on civil procedure a big gap?
It's certainly an area that later international standards and national systems have fleshed out much more. And then Article 12 rounds off this cluster, protecting against arbitrary interference with privacy, family, home, correspondence, and attacks on honor and reputation.
Okay. Articles 13 to 15 cover movement and status. Freedom of movement within borders and the right to leave any country, Article 13. The right to seek and enjoy asylum from persecution. Article 14, though, as the source notes, this isn't a right to be granted asylum, but to seek it and enjoy it if granted, and it has limitations, and the right to a nationality, Article 15.
Then we get to Article 16 on marriage and family. The right to marry and found a family, equal rights during marriage and at its dissolution, requirement of free and full consent. The source points out, though, how this article, which seems fairly straightforward, actually touches on some deeply contested issues.
Like what?
Well, things like potential conflicts with cultural or religious practices leading to discrimination, arranged marriages versus free consent. The specific wording men and women, which at the time was seen as limiting marriage to opposite-sex couples, that's obviously debated now, and even the definition of family itself. Is it just the nuclear family? It definitely reflects the social context of 1948. A bit conservative, perhaps.
Yeah, you can see that. Article 17 covers property, the right to own property alone or with others, and not to be arbitrarily deprived of it. Again, the source notes property isn't defined, and deprivation isn't banned outright, only if it's arbitrary.
Articles 18, 19, and 20 are often seen as the core Western civil liberties. Article 18, freedom of thought, conscience, and religion, including the freedom to change your religion or belief and manifest it. Article 19, freedom of opinion and expression, holding opinions without interference, and seeking, receiving, and imparting information and ideas through any media and regardless of frontiers. Article 20, freedom of peaceful assembly and association, and importantly, no one can be compelled to belong to an association.
Hugely important freedoms, but also where rights can really collide, can't they? The source gives examples like balancing free speech, Art 19, against protecting religious sensibilities, Art 18, or how limitations on things like hate speech or war propaganda under assembly rights, Art 20, might curb expression, Art 19. It highlights the tricky balancing act needed, which the UDHR itself doesn't really detail.
Exactly. They demonstrate that inherent complexity. Then Article 21 moves into political participation. The right to take part in government directly or through chosen representatives, equal access to public service, and this really foundational idea that the authority of government must come from the will of the people, expressed in genuine periodic elections with universal and equal suffrage, held by secret vote.
This article sounds very democratic, but as the source reminds us, under international law itself, there isn't actually a legal right for individuals to live in a democracy. Still, having this standard in the UDHR, it must influence expectations and maybe behavior.
Oh, undoubtedly. It sets a powerful political and moral benchmark, even if it doesn't create a strict legal obligation for states to adopt a democratic structure.
Okay, next up, Articles 22 to 25. This is the cluster covering economic, social, and cultural rights, often called ESC rights. These are often seen as requiring more positive action from the state compared to more hands-off, negative obligations of many civil and political rights.
That's the traditional view, yes. These are often framed as rights to something, rather than just freedoms from state interference. Article 22 kicks it off with Social Security. It's the first classic ESC right listed, explicitly linked to dignity and personality development. But notice the wording entitlement to realization through national effort and international cooperation and in accordance with the organization and resources of each state. It's a broad goal, laying the groundwork for the later ICSCR.
So it acknowledges resource constraints from the start.
It does. Then Article 23, the right to work. This includes free choice of employment, just and favorable conditions, protection against unemployment, equal pay for equal work, just remuneration, ensuring dignity, and the right to form and join trade unions. It clearly builds on non-discrimination, Art 2, and assembly association rights, Art 20.
Article 24 seems related. Rest and leisure, including reasonable working hours and paid holidays.
Yeah, it follows logically from Article 23, emphasizing humane working conditions, the need for recovery time, and of course this has economic implications for states and employers.
And Article 25 is a big one. The right to an adequate standard of living, including health and well-being. This covers basics like food, clothing, housing, medical care, necessary social services, and security in case of unemployment, sickness, disability, widowhood, old age, etc. It also mentions special care and assistance for motherhood and childhood.
This standard of living right, Article 25, has really been unpacked and expanded significantly in later treaties, like the ICSCR itself, and specialized ones like CEDAW on women's rights.
Makes sense. Article 26 is about education, framed as fundamental, partly because, well, how can you know or claim your other rights without education?
Exactly. And it outlines key state obligations. Elementary education should be free and compulsory. Technical and professional education should be generally available. Higher education should be equally accessible to all based on merit, so non-discrimination again. The purpose isn't just skills, it's the full development of the human personality, strengthening respect for human rights, promoting understanding, tolerance, friendship among nations and groups, and furthering UN peace activities.
It also mentions a parental right to choose the kind of education.
Yes, a prior right for parents to choose, though presumably within the framework of state standards.
Okay. Article 27 is about cultural life, arts, and science. It focuses on the right to participate in cultural life, enjoy the arts, share in scientific advancement, and protection of moral and material interests from scientific, literary, or artistic production intellectual property.
And the source material finds this one a bit curious. It suggests the focus seems to be on culture, as maybe a leisure activity or something for elites, rather than the fundamental right to one's own culture, language, traditions, identity, which is so crucial, especially for minorities. And including IP rights here feels a bit distinct from the other fundamental rights.
Yeah, it does stand out a bit. Article 28 is maybe the most abstract, a right to a social and international order where all the UDHR rights can be fully realized.
The source calls it anomalous and marginalized. It's difficult to pin down what it means in practice. Is it about states cooperating globally to create the conditions for rights? It hasn't been heavily relied upon, though you sometimes see it cited in campaigns around global poverty or international justice.
Then Article 29 is critical. It introduces the concepts of duties and limitations. It explicitly states that rights aren't absolute and come with duties to the community. Paragraph 2 is key. It spells out when rights can be limited.
Exactly. Limitations must be determined by law, solely for the purpose of securing due recognition and respect for the rights and freedoms of others, and meeting the just requirements of morality, public order, and the general welfare in a democratic society.
And the source emphasizes a crucial principle, even if not explicit in the text: proportionality. Any limitation has to be proportionate to the aim. You can't use a sledgehammer to crack a nut.
Absolutely vital principle. You can't restrict a right more than is strictly necessary to achieve that legitimate aim.
And finally, Article 30 acts as a safeguard. It says nothing in the UDHR can be interpreted as implying any right to engage in activity aimed at the destruction of any of the rights and freedoms set out in it. Rights might conflict and need balancing, but you can't use one right to completely eliminate another.
It's a sort of non-destruction clause.
So having walked through all that, the grand principles, the specific rights, the limitations, the source material, leaves us with a question. Is the UDHR, with all its breadth, its occasional vagueness, its inherent tensions, is it an incoherent jumble? Or is it actually a coherent vision for a rights-respecting society?
It's definitely ambitious, isn't it? Covering civil, political, economic, social, cultural rights all in one go. Some parts feel maybe more solid or immediately actionable than others. But the attempt to lay out that holistic vision, a vision of what a just and free society looks like, that's undeniable. It absolutely set the benchmark, even if the path to making it legally binding and truly implementing it was still long and uncertain.
It became the reference point, the aspirational standard that guided everything that came after.
Which leads us to the legal developments of the two covenants, and also brings us to thinking about the different types of mechanisms within the UN human rights system, broadly the charter-based ones and the treaty-based ones.
Right, let's refresh that distinction. Charter-based mechanisms, like the Human Rights Council we have now, they get their authority directly from the UN Charter itself. They operate within that broader, often more political UN framework.
Whereas treaty-based bodies, like the Human Rights Committee that monitors the ICCPR, they are created by specific human rights treaties. Their job is to monitor how states that have ratified that specific treaty are actually implementing it.
And the source materials suggest the dynamic tends to be different, right? Charter bodies are often seen as more political, while treaty bodies are meant to be more expert-driven, more focused on the legal aspects, although, politics is never entirely absent.
That distinction is really helpful for understanding the different strengths and maybe weaknesses of each approach. Let's look at the charter bodies first, starting with the legacy of the original Commission on Human Rights.
Okay, this was the body ECOSOC set up back in 46 using Article 68. We know it drafted the UDHR. And it also drafted the two covenants adopted in 66, plus a whole load of other key treaties, like the Convention Against Torture, CAT, and the Convention on the Rights of the Child, CRC.
Yes, the source really emphasizes the Commission's huge success in standard setting, creating the norms, drafting the legal texts. Often it was easier to get agreement on specific issues, like torture or children's rights, than on the massive overarching covenants.
But where it really fell down, according to the source, was in monitoring implementation. Why did it struggle so much to actually hold states accountable?
Well, right from the beginning, back in 1947, the Commission basically said it couldn't handle complaints about violations. That was largely down to that Article 27 non-intervention principle again. States were just very resistant to international scrutiny of their internal affairs, but maybe even more damaging over time was how heavily politicized it became.
Politicized has.
The source describes it becoming a sort of political football field, where states used human rights issues to attack their opponents while protecting their friends. It would condemn some countries with terrible records, but shield others, often powerful states or their allies, who were doing things just as bad or worse.
Can you give an example?
The source mentions the dynamic where certain states, particularly some Arab states and their allies, would consistently condemn Israel's human rights record concerning Palestinians, which the source acknowledges was and is serious and deserves condemnation. But at the same time, they'd block scrutiny of their own, often pervasive human rights abuses. And powerful states like China, with lots of allies and influence, could largely deflect serious criticism.
So its credibility just evaporated because it wasn't applying the standards fairly or universally?
Exactly. Selectivity kills credibility in a system like this. That's why it was eventually replaced in 2006 by the Human Rights Council, the HRC.
Okay, the HRC is the successor. Has it managed to escape that politicization trap completely?
Well, the source is realistic. It acknowledges it hasn't totally escaped it. I mean, it's a body made up of state representatives, so politics is always going to be there. But the argument is, don't write it off entirely. It has introduced some new mechanisms designed to be more universal and less selective than the old commission.
And the big one, the most well-known new mechanism, is the Universal Periodic Review, the UPR.
Yes, the UPR is a really key innovation. What it does is review the human rights records of all 193 UN member states, every single one, on a regular cycle, roughly every 4 to 5 years. That universal approach is the big difference from the old days of selective country resolutions.
How does the UPR actually work in practice?
It's basically a peer review system. The state being reviewed submits its own report on how it's doing. That's looked at alongside reports from UN bodies and, really importantly, reports from civil society, international NGOs, national NGOs. Then there's an interactive dialogue session where other states ask questions and make recommendations to the state under review.
A peer review. Isn't there a risk that states will just, go easy on each other? You scratch my back.
That's always a risk, sure. But the source highlights several real values of the UPR. First, universality, every state gets looked at, which tackles that old selectivity problem head on. Second, actually, many states do engage seriously and use it for self-reflection and potential reform. Third, even though it's peer review, states with really bad records can face significant pressure, sometimes even from their usual allies. And fourth, crucially, the input from NGOs and civil society gives a much more rounded picture than just the state's own version of events. It also acts as a platform for sharing good practices between states.
Okay, so it's not perfect, it's still political, but it introduces this systematic universal review process that brings a level of accountability that just wasn't there before.
Yes, that universality is a major plus. Now, another absolutely vital charter-based mechanism is the system of special procedures.
Special procedures, who are they? What do they do?
These are independent human rights experts. They're known as special rapporteurs or independent experts or members of working groups. The HRC appoints them, but, and this is key, they serve in their personal capacity. They don't represent their home governments. They've actually been around in some form since the late 70s, but the system was really consolidated and expanded under the HRC.
And they have different types of jobs, different mandates.
Exactly. Some have thematic mandates. They focus on a specific human rights issue globally. Think of a special rapporteur on torture, or the right to food, or freedom of religion, indigenous peoples' rights, arbitrary detention loads of them. Others have country mandates. They look at the human rights situation in one specific country or territory, like the special rapporteurs for the occupied Palestinian territories, or for North Korea, Myanmar, places like that.
The source mentions there are quite a lot of them now, a proliferation, which could risk diluting focus maybe, but it also means broader scrutiny and helps push the understanding of rights forward.
And their value is really immense. They do country visits, they write detailed reports, they engage in dialogue with governments, they can send urgent appeals or letters about specific alleged violations. The source gives the Right to Food Special Rapporteur as a really good example of how they contribute to developing the norms, the understanding of a right.
How did the Right to Food Rapporteur do that?
Well, their work gradually expanded the understanding of the right to food. It wasn't just about what a state does domestically for its own people. It started looking at how a state's actions internationally, things like its trade policies, its aid programs, could actually harm the right to food in other countries. This helped push for mainstreaming human rights thinking across different bits of the UN system and international relations generally, building on ideas from people like former Secretary General Kofi Annan.
That's a great example. How these independent experts can really push the thinking on what state obligations entail.
Okay, so summing up the charter side, we have the HRC, the UPR review for everyone, and these independent special procedures experts. They operate under the charter, tend to be more political. And then the treaty-based bodies, they're linked directly to specific treaties.
Exactly. Treaty bodies are committees of independent experts. They are established by the human rights treaties themselves. Their whole purpose is to supervise how the states that have joined that particular treaty are implementing it. Their authority comes from the treaty text, not the UN Charter directly, and they tend to be more focused on legal interpretation, detailed analysis.
And pretty much every major UN human rights treaty has one of these monitoring bodies. For the core ones, yes. You've got the Human Rights Committee, HRC, yes, confusingly the same acronym as the Council, which monitors the ICCPR. The Committee on Economic, Social, and Cultural Rights, CESCR, monitors the ICSCR. Technically, ECOSOC set it up, but it functions like a treaty body. Then CERD for the Race Convention, CEDAW for the Women's Convention, the Committee Against Torture, CEDAT for the Torture Convention, CRC for the Rights of the Child, CMW for Migrant Workers, CRPD for Persons with Disabilities, and CD for Enforced Disappearances. Again, these committee members are experts elected by the states parties to that treaty, but serving in their personal independent capacity. They're meant to be impartial.
Okay. This brings us right back to the backbone of the legally binding system then. Those two big covenants, the International Covenant on Civil and Political Rights, ICCPR, and the International Covenant on Economic, Social, and Cultural Rights, ICECR, which together with the UDHR make up what's often called the International Bill of Human Rights.
And it's worth remembering that history again. The initial idea after the UDHR was just one binding treaty. But the Cold War was raging. You had newly independent states emerging with very different priorities and ideologies. They just couldn't agree on how to implement and enforce all those rights, civil, political, economic, social, cultural, in a single document.
So the compromise was to split them, two separate covenants, both adopted in 1966.
Exactly. And think about that timeline. The UDHR was 1948, the covenants weren't adopted until 1966, and they didn't even enter into force until 1976. That 30-year gap really tells you how difficult it was to get states to sign up to legally binding human rights obligations. The split itself was fundamentally driven by this perceived difference in the nature of the rights.
Right. Civil and political rights were generally seen as things states should do immediately, rights that could be enforced by courts justiciable. Whereas economic, social, and cultural rights were often seen more as goals, things states should work towards over time, depending on resources.
That was definitely the dominant view that led to the split. Let's dig into the ICCPR first, the civil and political rights one.
Okay. So this covenant takes many of the civil and political rights we saw in the UDHR and makes them legally binding for the states that ratify it. The core rights are often said to be in Part 3, Articles 6 through 27, things like the right to life, Article 6 with details on the death penalty, freedom from torture, Article 7, freedom from slavery, Article 8, rights related to liberty and security of person, fair trial, due process, that's Articles 9 to 17, freedom of movement, Articles 12, 13, privacy, Article 17, the fundamental freedoms like thought, expression, assembly, Articles 18, 22, rights relating to family, Article 23, children, Article 24, political participation, Article 25, equality before the law, Article 26, and rights for persons belonging to minorities, Article 27.
Now, a really crucial concept for understanding what states have to do under the ICCPR comes from how the Human Rights Committee has interpreted Article 2. It's the framework of tripartite obligations. This is absolutely key for you to grasp. Respect, protect, promote.
Okay, the tripartite obligations. How do those three parts work? Respect, protect, promote.
Okay, first, respect. This is generally seen as a negative obligation. The state itself must refrain from violating the rights. So the state shouldn't torture people, it shouldn't arbitrarily detain them, it shouldn't censor their speech directly. It's about the state holding back.
Got it.
Just
State holds back. What's protect?
second, protect. This is a positive obligation. The state has to take active steps to prevent others, non-state actors, like individuals or corporations, from violating people's rights. So this means having laws against discrimination by private employers, laws against domestic violence, and having police forces that actually protect people from harm by others.
Okay, so protect is about the state stepping in to stop others from violating rights. And the third one, promote.
Third, promote. This is also a positive obligation. The state needs to take measures to actually facilitate the realization of rights, to help people access the systems to claim their rights. Think about providing legal aid so someone can challenge an unfair detention or running public education campaigns so people know what their rights are. That's promotion.
Respect. State refrains. Protect. State prevents others. Promote. State enables access. That's a really clear framework for state duties under the ICCPR. Very helpful.
It's essential. Now, the covenant also talks about when rights can be limited. Article 4 deals with derogation. This allows states to temporarily suspend certain rights, but only in a time of officially declared public emergency that threatens the life of the nation. And even then, there are strict conditions. Plus, some core rights can never be suspended. They are non-derogable, like the right to life, freed from torture, freedom from slavery, freedom of thought, conscience, religion.
Right. And states can also make reservations when they join, saying they won't apply certain bits.
Yes, but again, with limits. A state can say, we don't agree to be bound by Article X. But under international law, a reservation can't be incompatible with the object and purpose of the treaty. You can't make a reservation that guts the whole point of the treaty. And the Human Rights Committee has taken on the role of assessing whether reservations made by states are actually valid under that rule.
And Article 50, the federal state clause, that seems important too, especially for big countries like the US or Australia.
Yes, Article 50 is crucial for federal states. It makes it clear that the obligations in the covenant apply to all parts of the federal state, central government, regional governments, local governments, without any limitations or exceptions. It stops the central government from saying, oh, well, freedom of speech is handled by our provinces, so it's not our international responsibility. It ensures the treaty applies everywhere within the state party's territory.
Okay, that covers the ICCPR. Let's switch over to the other big one, the ICSCR, the International Covenant on Economic, Social, and Cultural Rights.
The sister covenant right. Its preamble immediately links it back to the UDHR and the ICCPR. It talks about the ideal of free human beings enjoying freedom from fear and want, and says this can only be achieved if conditions are created where everyone can enjoy both their economic, social, and cultural rights and their civil and political rights. It really stresses that all rights are interconnected.
And it starts with Article 1, the right to self-determination, same as the ICCPR.
Exactly the same. Reinforcing how fundamental that is, linking people's political status to their ability to pursue their economic, social, and cultural development and control their own resources, though it also mentions the duty of international cooperation.
Now, the core obligation for states under the ICSCR, the concept that really sets it apart from the ICCPR's generally immediate obligations, is progressive realization. That's in Article 2, right?
Absolutely fundamental to the ICSCR. Article 2, Paragraph 1. States parties agree to take steps to the maximum of their available resources with a view to achieving progressively the full realization of the rights recognized in the present covenant by all appropriate means, including particularly the adoption of legislative measures.
Okay, take steps. Maximum available resources, achieving progressively. So it acknowledges that fully realizing rights, like housing for everyone, or universal health care, or quality education for all, it takes time. And it depends on how wealthy the country is.
Precisely. It's not an obligation to guarantee these rights perfectly, immediately, for everyone. It's an obligation to take deliberate, concrete steps using all the resources you reasonably have available to move towards the goal of full realization over time.
Mhm.
But, and this is crucial, the concept of minimum core obligations has developed largely through the work of the Committee on ESC Rights. This is equally vital to understand.
Minimum core obligations, what does that mean?
It means that even with progressive realization and resource constraints, there's a basic, essential level of each ESC right that a state must ensure immediately for everyone. Think about ensuring access to minimum essential food, basic shelter, essential primary health care, basic primary education. Failing to meet this minimum core level is considered a violation of the covenant, even for developing countries. Although Article 2.3 does allow developing countries to make some distinctions regarding economic rights for non-nationals.
So even if the full right takes time, there's a non-negotiable baseline that has to be met right now.
Exactly. You can't use progressive realization as an excuse to do nothing about people starving or having no access to basic schooling. The key ESC rights listed in the Covenant, Articles 6-15, include the right to work and just conditions, Art 6-8, Social Security, Art 9, protection of the family, mothers, children, Art 10, the right to an adequate standard of living, including food, clothing, housing, Art 11, think about homelessness or inadequate housing, even in rich countries. The source mentions UN stats on this. The right to the highest attainable standard of physical and mental health, Art 12. The right to education, Art 13. And cultural rights, Art 15.
And again, unlike many civil rights where the state might just need to not interfere, these ESC rights clearly require the state to take positive action to fulfill them. Build the schools, train the doctors, set up the social safety nets.
Yes, they demand significant state investment planning and programs.
Yeah.
Now, that historical debate about whether these rights were just policy goals or if they had real legal content that courts could handle, that debate has largely moved on. It's now widely accepted that ESC rights do have definable legal content, which was important for eventually creating mechanisms like individual complaints.
So, comparing the two covenants again, the key difference really boils down to the nature of the main obligation. Generally, immediate respect promote for ICCPR rights versus progressive realization tempered by minimum core obligations for ICSCR rights.
That's the core distinction, yes. And historically, that difference heavily influenced how monitoring and enforcement were approached, although, as we'll see, that gap has narrowed somewhat over time, especially with the ICSCR eventually getting its own individual complaints mechanism.
Right. So let's talk about how these legally binding obligations in the covenants are actually monitored. This is where the treaty bodies and their specific mechanisms come into play.
The main treaty bodies for the covenants are, again, the Human Rights Committee, HRC, for the ICCPR, and the Committee on Economic, Social, and Cultural Rights, CESCR, for the ICSCR. And remember, these are committees of independent experts elected by the states' parties serving in their personal capacity. They're supposed to be impartial overseers.
Okay. And the first mechanism, the one that's compulsory for every state that joins a treaty, is state reporting.
Yes, this is the foundation stone of treaty supervision. States that ratify are legally required to submit an initial report fairly soon after joining, like 1 year for ICCPR, 2 for ICCR, and then they have to submit periodic reports detailing their progress in implementing the treaty at intervals set by the relevant committee, typically around 5 years for CESCR. Those cycles vary and delays are common.
Okay. Sounds a bit, well, bureaucratic. Filing reports. What's the actual value? The source material listed quite a few benefits.
Yeah, it can seem bureaucratic, and states can try to just go through the motions. But the reporting process, when it works well, is actually crucial for several reasons. Let's list them. 1. It forces the state itself to think about what its treaty obligations mean in its own specific national context. 2. Preparing the report ideally involves a self-assessment. The state has to take stock, look at its laws and practices, identify where things are good, where the gaps are, what needs reform. 3. The process within the government, ideally involving consultation across different ministries, maybe even with civil society, can itself improve understanding and coordination domestically. 4. The report and the dialogue around it becomes public information. This can raise awareness among the public, NGOs, the media about the treaty and the rights involved. 5. It creates a structured dialogue between the state representatives and this committee of independent, impartial experts. It's a chance for constructive feedback, technical advice. 6. States can share good practices, learn from what others are doing. 7. And the outcome, the committee's concluding observations and recommendations provides authoritative guidance. It tells the state what the experts think needs improving. And that guidance is useful not just for the government, but for domestic courts, national human rights institutions, NGOs, other states. It becomes a benchmark.
So it's less about punishment and more about transparency, dialogue, self-reflection, and expert guidance.
Exactly. It's a primary tool for promoting implementation and accountability through scrutiny and cooperative dialogue. But let's be honest, the source correctly points out the persistent problems. States are often very late with reports, sometimes don't submit them at all, reports can be superficial or defensive, and crucially, states often just ignore the recommendations they receive from the committees.
Okay, so reporting is the baseline, but it has its issues. What's the second key mechanism, the one that's optional? Individual communications or petitions?
Right. This allows individuals who claim that their rights under a specific treaty have been violated by a state party to bring a complaint directly to the relevant treaty body.
And the source calls this a quasi-judicial process. Why quasi? It's not quite a court case, is it?
Exactly. It's quasi-judicial because it has court-like features receiving evidence, hearing arguments from both the individual, or their representative, and the state, making findings based on legal interpretation of the treaty. But the outcome isn't a legally binding judgment like you'd get from a national court, which the police could enforce. The treaty body issues views or recommendations. They state whether, in the committee's expert opinion, a violation occurred and suggest what remedies the state should provide, like compensation, release from prison, changing a law. These views are considered highly authoritative, carry significant moral and legal weight, but states aren't legally forced to comply in the same way as with a domestic court order.
Okay, so how does an individual actually bring a complaint? Let's say under the first optional protocol to the ICCPR, which set up this system for that treaty.
Well, the individual, or someone on their behalf, with consent, submits a written communication to the Human Rights Committee. It then has to get past several admissibility criteria. These are really important hurdles. The most significant one is that the individual must have exhausted all available domestic remedies.
Meaning?
Meaning, you have to try and get justice through the courts or other relevant bodies within your own country first. You have to appeal up through the national system as far as is reasonably possible. Only if those domestic remedies have failed, or if they are taking an unreasonably long time, or if they are clearly ineffective or unavailable, can you then take your case to the international treaty body.
So it's definitely a mechanism of last resort. You can't just bypass your own country's courts.
No, absolutely not. Other admissibility criteria include things like the complaint can't be anonymous, it can't be an abuse of the process, like just repeating a claim already dismissed, and the same matter shouldn't be currently pending before another international investigation or settlement procedure.
Okay, if it gets past those hurdles, if it's admissible, what happens then?
The committee then looks at the merits, the substance of the claim. It brings the communication to the attention of the state party concerned. That's Article 4 of the optional protocol. And the state usually gets 6 months to provide its written explanations or statements clarifying the matter and any remedy it might have already taken. Then, based on all the information from both sides, the committee considers the case in closed meetings and adopts its views.
And you stressed this whole mechanism is optional. States have to specifically agree to let their citizens bring complaints against them.
Yes, absolutely optional. A state must explicitly accept the competence of the treaty body to receive and consider individual communications. Usually this is done by ratifying a separate treaty called an optional protocol, which specifically creates this complaints mechanism. The first optional protocol to the ICCPR, adopted back in 1966 along with the Covenant, is the classic example. The optional protocol to the ICSCR came much later, adopted in 2008, entering into force in 2013, largely because of that long-standing debate about whether ESC rights were enforceable in this way. Other treaties, like CEDAW and CRC, also have optional protocols for complaints. Sometimes the mechanism is actually included within the main treaty text itself, like in Consent Article 22 or ICERT Article 14, but even then, states usually have to make a separate declaration specifically accepting that competence.
Okay. So what's the real value of this individual complaint system, given that the views aren't strictly binding like a court order?
Its value is actually quite significant in several ways. One, for the individual victim, it offers a potential avenue for justice and redress when their own national system has failed them. That's hugely important symbolically and sometimes practically. Two, the process leads to very detailed, case-specific legal analysis by the treaty body experts. This really helps to clarify what the treaty provisions mean in practice. Three, the published views, even if not binding name and shame states found to be in violation. This can create pressure of political, diplomatic, public for the state to provide a remedy or change its laws or practices. Four, over time, the body of jurisprudence built up from these individual cases significantly contributes to the progressive development and consolidation of human rights standards. It fleshes out the meaning of the rights. Five, NGOs often play a critical role, helping individuals bring cases, providing expertise, and then using the outcomes in their advocacy work to push for broader changes.
So it serves multiple purposes: potential redress for victims, clarifying the law, putting pressure on states, and developing the standards over time, even without direct enforcement power.
Exactly. It's a form of quasi-judicial accountability and a powerful engine for normative development.
Okay. Then the third mechanism mentioned is interstate petitions. This is where one state complains about another.
Yes. This mechanism allows one state party to a treaty to bring a claim against another state party, alleging that the second state is not fulfilling its obligations under that treaty. The complaint goes to the relevant treaty body.
Why would this mechanism even exist? States complaining about other states' human rights records.
The rationale is based on the idea that human rights treaties create obligations, erga omnes parts, obligations owed by each state party to all other state parties. So, in theory, all states parties have a legitimate legal interest in ensuring that every other state party complies with the treaty. A violation by state A is, in a sense, a breach of the treaty that affects state B, state C, and all the others.
Okay, that's the theory. But the source material flatly states it's rarely used. How rare is rare?
We're talking virtually unused. In the entire history of the core UN human rights treaty system, no state has ever actually initiated a formal interstate complaint against another state under these provisions. The mechanism exists. It's usually optional, like under ICCPR Article 41, requiring a specific declaration, but states are just extremely reluctant to go down that road. It's seen as a very politically confrontational step to formally accuse another state of violating a human rights treaty in this quasi-judicial forum.
So it's basically a tool that sits in the toolbox but never gets taken out because it's too politically sensitive.
Pretty much, yes. States prefer other ways to raise concerns: bilateral diplomacy, statements in political bodies like the HRC or General Assembly, maybe supporting NGO reports, not formal legal complaints against each other.
Okay. Beyond those three main mechanisms reporting, individual petitions, interstate petitions, treaty bodies also do other important things like issuing general comments.
Yes, general comments are incredibly important outputs. These are the treaty body's authoritative interpretations of specific articles or broader themes within their respective treaties. They draw on the committee's experience from reviewing state reports, considering individual complaints, and holding thematic discussions.
And what's their significance? Why are they so important?
They are crucial for clarifying the scope and meaning of the rights and the corresponding state obligations. They fill in gaps in the treaty text, address new issues that arise, and provide detailed guidance to states on how they should be implementing the treaty in practice. They aren't legally binding in the same way the treaty itself is, but they carry enormous persuasive weight. Courts, governments, NGOs, academics, everyone looks to general comments for guidance on what the treaty means. They really drive the progressive development of human rights law.
Got it. And finally, the source briefly mentioned additional substantive protocols.
Right. These are basically separate treaties that add new rights or obligations onto an existing main treaty. For example, the second optional protocol to the ICCPR aims at the complete abolition of the death penalty. The Convention on the Rights of the Child has optional protocols dealing specifically with children in armed conflict and with the sale of children, child prostitution, and child pornography.
So they allow states to take on deeper commitments on specific issues, if they choose to.
Exactly. Their optional states have to choose to ratify them separately, but you generally have to be a party to the main treaty first. They show how human rights standards continue to evolve and become more detailed over time, responding to specific concerns.
Okay, we've mapped out the whole system, charter-based, treaty-based, the covenants, the mechanisms. But the source materials spend quite a bit of time on the serious challenges and criticisms facing this UN human rights system and the ongoing efforts to reform it. It doesn't sound like everything's working perfectly.
Far from it. The system, particularly the treaty body system, is frequently described as being under immense strain, sometimes even in crisis. The challenges are significant, they're numerous, and they've been around for a long time.
What are some of the biggest problems this system is grappling with?
Well, the source lists several key ones, focusing on the treaty bodies. First, state reporting. States submitting reports incredibly late, or sometimes not at all. Reports that are submitted are often inadequate, lacking detail, or just painting a rosy picture. Second, lack of cooperation. States not engaging constructively with the committees, or worse, simply ignoring their concluding observations and recommendations. There's a major implementation gap.
Potential overlap in the work between different treaty bodies examining similar issues in the same country, or overlap between treaty bodies and charter-based mechanisms like the UPR or special procedures. This can lead to inconsistent recommendations or wasted effort. Fourth, workload and resources. This is huge. The treaty bodies face a massive backlog of state reports to review and individual communications to consider. There simply aren't enough committee members or meeting time allocated to deal with the sheer volume of work properly. This leads to long delays.
Wow, that sounds like a system really struggling to keep up and facing real resistance from the very states it's supposed to monitor.
It absolutely is. And this talk of a crisis isn't new. It's been discussed for well over 2 decades. There have been countless calls for reform, including formal ones from the UN General Assembly itself, like Resolution A68L.37 mentioned in the materials.
And the source details some more recent reform efforts, particularly those initiated by the treaty body chairs themselves, outlined in that 2019 position paper, A74256. What kinds of things were they proposing or agreeing on?
A key aspect of that 2019 push was the treaty bodies trying to take more control of the reform process themselves, rather than waiting for states' parties, who might be reluctant to agree to stronger measures. The steps they agreed on focus mainly on improving efficiency and consistency. Things like 1. Better alignment of working methods across the different committees, make things more predictable for states and stakeholders. 2. Wider use of the Simplified Reporting Procedure, SRP. Instead of a long narrative report, the committee sends the state a focused list of questions in advance, list of issues prior to reporting, or LOIPR, and the state's report just answers those questions. It's meant to be less burdensome. 3. Coordinating better to reduce overlap, for example, by coordinating the list of issues sent to states when multiple committees are reviewing them around the same time. 4. Trying to manage reporting cycles and timing better to smooth out the workload. 5. Offering states the option of submitting joint or common core documents covering related treaties, like the ICCPR and ICCR together. 6. Standardizing the format for how reports are actually considered in the dialogue sessions. 7. Making more use of technology like video conferencing for dialogues with state delegations. 8. Trying to make the concluding observations shorter, more focused, more concrete, maybe distinguishing between immediate priorities and longer-term goals. 9. Looking at ways to increase their review capacity, maybe working in smaller chambers or groups, using country teams to get through more reports each year. They were aiming for something like 25-50 reports annually across the system. 10. Exploring ideas like regional dialogues or reviews.
Okay, those sound like sensible, practical steps, mostly focused on streamlining the process, making it more efficient, more consistent. But do they really get at the fundamental problem? The lack of political will from some states to cooperate fully or implement recommendations?
That is the million-dollar question, isn't it? The source is cautious. It says, basically, the jury is still out on what real difference these changes will make. How will states actually respond? Will a simpler reporting procedure lead to better, more timely reports and more engagement? Or will the underlying resistance just continue? The fact that this crisis talk has persisted for so long suggests the challenges are very deep-seated, probably beyond just procedural tweaks.
Right. Let's try and bring some of these different pieces together now. How did these different parts of the UN system, the charter-based mechanisms, HRC, UPR special procedures, and the treaty-based bodies, How do they actually interact? Do they complement each other? Do they clash?
That's a really important question. The source asks, are the charter mechanisms still valuable alongside the treaty bodies? And the answer seems to be yes, definitely. Despite the risks of politicization in state-led bodies like the HRC, they offer things the treaty bodies can't. The UPR provides that universal scrutiny. Every single state gets reviewed, which treaty bodies don't do. They only review states' parties to their treaty. Special procedures offer independent, flexible investigation, thematic expertise, and the ability to react quickly to urgent situations, often much faster than the more deliberative treaty body process. And as we discussed, special procedures are vital for developing standards that then feed into treaty body interpretations.
So they offer different angles of attack, different strengths, universal peer review from UPR, expert legal review from treaty bodies, independent investigation from special procedures.
Exactly. They should be complementary. The UPR's peer review can reinforce or be informed by the treaty body's expert findings, and vice versa. Special rapporteurs' reports provide crucial context for treaty body reviews. The big challenge, as mentioned in that Tistanet reading the source refers to, is ensuring effective coordination between all these different mechanisms, so they're not duplicating effort or sending contradictory messages, making the whole system work together more coherently.
And what about the relationship within the treaty body system itself, between the state reporting process and the individual communications mechanism?
The source points to a potential tension there. Remember, it's the same committee of experts doing both things. They have a dialogue with the state based on its report, trying to be constructive, but then they might also sit in judgment on an individual complaint against that same state, acting in that quasi-judicial role. The concern is, could this make states less open and honest in their reports? Might they hold back information if they fear it could be used against them later in a complaint?
Yeah, I can see that. You might be hesitant to admit shortcomings in your report if the same people reading it might then find you in violation based on those admissions in a specific case.
It's a potential chilling effect. However, the source also argues they can be complementary. Individual communications provide that really specific, detailed analysis of how rights apply on the ground, highlighting noncompliance in a way a general state report might gloss over. Both processes feed into the development of standards. General comments draw heavily on insights from both reporting dialogues and complaint jurisprudence, and NGOs can strategically use complaints to push the committees to clarify or strengthen their interpretation of certain rights, which then influences future reporting reviews too.
So they offer different levels of scrutiny and engagement, both contributing to the overall goals of accountability and standard setting.
Precisely. Reporting is the broad, compulsory foundation. Communications provide the deeper, optional, case-specific legal accountability. Both are valuable parts of the toolbox.
Okay, this brings us right back to that fundamental challenge raised throughout the materials. What does enforcement actually mean in the context of the UN human rights system? The source really stresses, doesn't it, that we shouldn't think of it like domestic law with courts issuing binding orders backed by police power.
This is absolutely critical to understand. The UN system operates between sovereign states. It simply cannot function like a national legal system. States would never, ever agree to an international body having the power to issue legally binding judgments that could be directly enforced within their borders against their will. That would fly directly in the face of Article 2.7 and the whole principle of state sovereignty.
So if it's not enforcement in the traditional sense, what is it? How does the system try to ensure compliance?
It's much more multifaceted. Enforcement in this context really involves a whole range of activities and pressures. There's overseeing or supervision. Mechanisms like state reporting and the UPR bring state conduct under international review, requiring states to explain themselves. There's standard setting and interpretation. Drafting the treaties, adopting general comments, issuing legally reasoned views and individual complaints, all this clarifies what the rules are and how they apply. There's investigation and fact-finding. Special procedures going on missions, gathering information, documenting violations. There's dialogue and persuasion. The interactions between states and the committees or special procedures often involve technical advice, diplomatic engagement, trying to persuade states to change course. There's public reporting and shaming. Making the reports, findings, and recommendations public shines a spotlight on state practices, creating transparency and potential reputational costs for noncompliance. There's political and diplomatic pressure. The findings and scrutiny generated by the system can be used by other states, by NGOs, by domestic actors to put political pressure on the government concerned. And there's the moral and expert authority. The findings of independent expert bodies carry significant weight, even if not legally binding in a coercive sense.
Okay, so enforcement is really this broader combination of scrutiny, dialogue, interpretation, transparency, persuasion, and political or moral pressure. It relies heavily on states caring about their reputation, engaging in the dialogue, and hopefully responding to expert guidance and public scrutiny rather than direct legal force.
Exactly. It's about influencing state behavior through this complex web of mechanisms and pressures, always operating within the constraints imposed by state sovereignty. So, when you're assessing the effectiveness of the UN human rights system, you have to judge it based on how well these diverse tools actually manage to encourage compliance and promote respect for rights in that specific context. You can't judge it against the standard of a national court system because it was never designed to be that, and likely never could be given the nature of international relations.
That really clarifies the landscape. It's complex, it's imperfect, it's constantly evolving, always trying to balance these huge ideals with some very hard political realities.
It absolutely is. And understanding that balance, understanding the different tools and how they're supposed to work and where they fall short, that's the key to evaluating its real world impact.
So let's recap our journey. We started with the UN Charter's foundational ideals right after World War II. We saw how those were articulated into this grand vision in the Universal Declaration of Human Rights, then solidified into legally binding obligations in the two covenants, the ICCPR and the ICSCR, and then overseen by this whole array of mechanisms, the charter-based ones like the Human Rights Council, the Universal Periodic Review, the Special Procedures Experts, and the treaty-based bodies, the committees monitoring specific treaties through state reporting, and those optional individual petition systems.
And we've seen it's a system facing really significant ongoing challenges, issues with state cooperation, massive workloads, politicization, which has led to these continuous efforts at reform, particularly trying to make the treaty bodies more efficient and effective.
And grasping this whole multi-layered structure, with all its strengths, its weaknesses, its inherent limitations, it's just essential, isn't it? For anyone studying international law, international relations, or frankly, anyone just interested in how the world tries and sometimes struggles to uphold basic human dignity in the face of state power and political reality.
It really requires understanding the blueprint, the different parts of the machinery, the constant challenges, and crucially, remembering that enforcement means something quite different, quite multifaceted in this international arena.
Absolutely. Well, we sincerely hope this deep dive into the source material has been useful for you in navigating this incredibly complex but vital area. Definitely go back and revisit those documents from the University of London to really cement your understanding.
Yes, please do. And as you continue thinking about all this, maybe here's a final thought to leave you with. Given that persistent struggle to get states to fully comply, even with the existing mechanisms, how could we maybe better empower civil society groups or even individuals themselves to use these UN systems more effectively to demand accountability? Or perhaps thinking ahead with huge global challenges emerging climate change, artificial intelligence, pandemics. How well equipped is this system, designed largely in the mid 20th century, even with reforms, to really protect human rights effectively in the decades to come?
Really powerful questions to mull over. Thank you so much for joining us on this deep dive.
Yes, thank you. And again, good luck with your studies and your exams.